employers in order to make that as smooth and as beneficial, I think I should say, for everybody involved. So by way of introduction, we're going to cover what types of issues could crop up at work that would potentially lead to a disciplinary. We're going to look at whether formal or informal action will be necessary. An overview of the process, including whether or not it's appropriate to suspend an employee, the importance of a good investigation prior to a disciplinary being put forward, the disciplinary hearing itself and what things to consider there, and then also finally round off by talking about the importance of an appeal and the appeals process. So that is a broad overview of what we're going to be looking at today. So we've got quite a fair bit to cover. So without further ado, we'll crack on and get to the first slide. Oh. So what type of issues can occur at work? You know, if we were doing this module face-to-face with you all, I'd probably at this point be asking everybody to chime in with what type of things that they've encountered in their professional lives as HR managers and officers in their companies, what type of issues occur in your workplace. I mean, there's no wrong answer to this question. It's always going to be specific to your particular sector, your particular workplace. Some things that are going to be important for you are not going to be important for other employers. It stands to reason that an issue in, say, a manufacturing environment is not going to be that big of an issue, maybe in a retail environment, and vice versa. So some examples, one extreme examples could be employees fighting with one another, personality clashes, and things where people just don't get on. Also, you can think of maybe data breaches, confidentiality breaches, for those of you who deal with things like that. Health and safety issues. Again, I mentioned manufacturing before. Obviously, that would be a big one for anybody in the manufacturing sector. But the important thing to remember is that they are specific to your industry. There's no one size fits all, if you like, when it comes to what can constitute something that would need disciplinary action. What sort of the risks are not dealing with issues correctly? Well, the most important one, which we as lawyers are trained to think about, and I'm sure Chris will agree with me, is making sure that someone, if they are either dismissed or issued with a sanction, it's done correctly, so you don't get sued in an employment tribunal, which is obviously something that people are very conscious about, and we as lawyers are always constantly on guard of. But there are also other things to consider as well. So if a disciplinary issue isn't dealt with appropriately or adequately, it can sometimes lead to bad feeling within the company itself. So from an employee relations perspective, bad morale, allegations of unfair treatment. Say, for example, you discipline one employee for a particular offence and then you don't do anything when another employee does the same thing. There's all manner of things that can go wrong. So it's important to make sure that when a disciplinary process is commenced, it's done in a consistent and, I suppose, a procedural fashion, and providing that you follow that advice, you have a process and you follow it consistently and you apply those procedures and policies consistently, you won't go far wrong in terms of providing disciplinary sanctions or outcomes.
Okay, morning everyone. The first question I think is always necessary for you to ask yourself is, are we looking at a conduct issue or are we looking at a capability issue? And a lot of unprepared or inexperienced managers will often get these two issues confused. And I tend to think of it in a very simple way, in that conduct is won't do and capability is can't do. So conduct, we're looking at someone who has done or has not done something which they are capable of doing. And capability is an issue around skills, knowledge, experience, training, whether they are effectively up to doing the task that's expected of them. The definitions of conduct, misconduct and capability are there on the screen. They're also reproduced in your workbook. the key point around this is conduct and capability should never cross over. You should never be going through a conduct process with a capability issue and vice versa, nor should you be relying on a conduct warning or a capability warning and building on that with the opposite process. A conduct warning is a conduct warning, and a capability warning is a capability warning. So as it says there, conduct, the manner in which a person behaves, especially in a particular place or situation. Misconduct, unacceptable or bad behaviour by someone in a position of authority or responsibility. And capability is the power or ability to do something, or the extent of someone's or something's ability. Once you've decided that you have your conduct issue, then you have to look at, well, is this something which requires formal conduct disciplinary action following our disciplinary process, or is this in fact something that can be dealt with informally? And a lot of employers will be quick to jump to a formal process because for all intents and purposes, it's a more straightforward process if you have a very clear disciplinary policy in place, which gives you a process to follow. Whereas having an informal conversation is often a test of a manager's ability to manage an individual. And I think it shouldn't be underestimated the importance of an informal way of dealing with a particular issue. So I think the first question you've got to ask yourself as a manager is, well, what am I looking at? Is this something which is serious enough that informal action is not appropriate? And obviously, taking some of Dan's examples earlier, if two employees have had a fight, that isn't something that you're going to pull them to one side and deal with informally. That's something which is a serious breach of their obligations, and something which should be dealt with formally in order to avoid, I suppose, backing yourself into a corner should future incidents happen, and you've chosen to deal with that particularly serious issue informally, when you might want to take formal action against someone for doing the same thing later on down the line. But often an informal conversation can be a really useful tool for dealing with a small breach of someone's obligations, because we can reset the relationship, we can make it clear what people are required to do and what we expect of them. So in actually handling matters informally, if you've chosen to go through that route, obviously it's important to sit down with the employee and have that discussion with them, and understand what's happened and why it's happened. And this may, in fact, be part of your process for identifying, well, is this actually a conduct issue? Or is it a capability performance issue? Because this individual, although they say they understand what they're supposed to be doing and how to do it, it actually identifies a skills gap, which could be filled with further training or supervision, and it's a really useful tool in terms of performance management. If it is a conduct issue and we decide it's a momentary lapse in conduct that's appropriate to deal with informally, then obviously as part of this conversation it's important that we outline to them what we expect of them going forwards, and make it clear that they need to improve their conduct, and make it clear that we'll be supervising that improvement going forwards, because the simple fact of the matter is, if you deal with something informally, you set out the required standards and someone doesn't meet those standards in the future, that then may be a consideration that you take into account as to say, well, I can't deal with this informally again. This is something which now justifies the use of formal action as part of potentially a low-level warning. And as it says there, it's a balance of support and challenge. So we want to support our employees, of course we do. We don't want to be taking them through processes all the time and dealing with conduct issues all the time. We want to use the tools that are available to us to support them and improve their performance and their conduct in the workplace. So it is certainly a positive thing, but it's also important that we are challenging incorrect behaviour and making it clear what the standards we expect as their employer are and what they can do to meet those standards. So there's an informal feedback tool, which is quite a useful tool in your workbooks. It's referred to as the EEC model. It's on page 3. It's a really useful tool to follow in giving informal feedback. It gives you a really useful toolkit to give that feedback to employees and make sure that we're being clear on what we expect of them and also what's gone wrong. And like I say, it creates that positive and supportive environment. You're less likely to get some pushback from an employee if this is couched in terms of we are trying to help you, we're trying to improve you, and we're trying to develop you to be a better employee for the business. And it's not only about when something goes wrong and you may have a conduct issue. Performance management in and of itself should be something that is done on a day-to-day basis. We should be giving feedback all the time to our employees, making it clear what they've done well, making it clear what they could improve. And also it builds the relationships with the employees. There's less of a gap between management and employee if we're constantly having that conversation with them and trying to help them improve themselves as employees. So in terms of the actual informal discussions, it is important, even though this is an informal process, it's important to keep a record of what is discussed because, like I say, it outlines the targets and the expectations that we have of the individuals as part of this process. But also it serves as a record in case there is another slip up further down the line of a similar or the same nature. So it doesn't have to be particularly procedure driven. It doesn't have to be particularly complex in the way that you do this. A simple note on a file or a letter of concern. You normally hear about letters of concern being placed on individuals' personnel files, which don't particularly form part of any formal disciplinary process, but actually serve as a really useful record for noting the issues that we've identified and also the targets that we've set. And obviously, if we don't get that improvement going forward, then that's where you may move to a disciplinary process.
Okay, brilliant. Thank you, Chris. So Chris has obviously helpfully taken us through the informal method of approaching issues in the workplace. Obviously, the main meat and substance of today's webinar is an overview of the formal procedure. So on screen right now, the slide in front of you basically describes the lifetime, if you like, of a disciplinary issue. So at the very beginning, you can see that we've got suspension, and that's got a question mark in front of it, and that's important. I'll come back to that in a moment. Then the investigation, again, another probably very key important part of the disciplinary process. Case to answer and another question mark, again, that's important to consider. And then the disciplinary hearing itself, the outcome and delivery of that outcome, and then the appeals process. Now, that is sort of what we would describe as the lifespan of a typical disciplinary issue. Now, each of the separate sections in front of you on the screen are not necessarily going to be the same length in time. And that's important to consider because sometimes people think, well, we've got to complete an investigation within a certain amount of time. Obviously, the ACAS code dictates that you should always try to complete an investigation, say, for example, within, without unreasonable delay. However, it stands to reason that if it's a particularly serious allegation, you're going to want to spend, or the investigating officer is going to want to spend a fair chunk of time at the investigation stage just to make sure that all the issues are uncovered, because it so happens that when one allegation is made, say, for example, against an employee of misconduct or gross misconduct, during the course of the investigation, that can sometimes throw up even more serious issues, or issues that kind of implicate other employees as well, necessitating separate action against them. So it's important to remember that although this is the typical lifespan, if you like, of a disciplinary process, one section of this process may be longer than another one. There's no right or wrong way to do it. As long as you follow the process, you should be okay. So we're now going to watch a video, and this is one of the 6 videos that I mentioned earlier on, that kind of are going to help us to visualize, I suppose, if you like, I keep on referring to the lifespan of a disciplinary. This is the very, very beginning. So just to give you a bit of information about what's happened before this video, an employee has been caught with inappropriate images on his company laptop. On his company iPad, sorry. And at the moment, the employer has sort of been made aware of this information. They've called the employee in, and they're about to consider whether or not they want to suspend the employee. So I'll play the video, and then we'll begin discussing whether or not it's appropriate to suspend in every instance, and how to go about a suspension meeting and how not to go about it, which I think this video probably illustrates better. So I'll just let the video play, and then we'll talk about that afterwards.
Hi Eddie, I've invited you here today to make you aware that we're going to be suspending you without pay for the foreseeable future. I had some rather shocking allegations made against you by the IT team, which obviously we need to be looking into. So here's a letter explaining your suspension, and we'll be in touch.
Okay, so obviously fairly short and sweet, and riddled with issues, I would say. So, I mean, the first thing that kind of jumps out to me on watching this video as an employment lawyer, and as HR professionals and managers, you'll also probably be thinking, oh God, that wasn't very good. The main thing, I think, is that, you know, she brings him in, she passes him a letter in the meeting, and before anything else, before he even gets a chance to speak, he's just basically turfed out of the business and told to be on his merry way. Now, I mean, what they did get right is that they did suspend him on full pay, which is obviously correct. However, I think the manner in which the suspension was delivered in the form of a letter with no sort of recourse from the employee just kind of sends shivers down my spine in terms of process not being followed, or things not being done in quite the way that we would always advise. So suspension is obviously one of the things that when a disciplinary issue comes to the fore of, or comes to the attention rather, of the employer, it's always on their minds as to whether or not they can suspend. And sometimes I think it's one of the questions that myself and Chris and the rest of the team, when disciplinary issues are being questioned by our clients, it's one of the things that we probably get the most questions on, is whether or not I can suspend this person and how do I go about it. The first question you need to ask yourself is it always appropriate to suspend? Sometimes it won't be. It used to be the case that a lot of employers would think that once a disciplinary issue was brought to their attention, the knee-jerk response was to suspend immediately, just to prevent anything happening with that employee in the business. Oh, that employee's been accused of X. I don't want them in the business, so I'm going to suspend them whilst I investigate this. It's not always appropriate to do that, and there's been quite a lot of case law to establish that suspension is no longer regarded as a neutral act. So therefore, by suspending an employee, you have to consider whether or not it's appropriate to suspend. and also whether or not you've got the contractual right to do so. It's true that a contractual right to suspend could be implied into the contract, but I would say that if there's one message from me anyway to take away from this webinar today, it's to stop and to think about what you're about to do. You should always really stop and think before you take any action in respect to the disciplinary process, especially when it comes to suspension. If you suspend without the contractual right to do so, or the implied right to do so, you could run the risk of a breach of contract claim. And it's just not always appropriate in the circumstances. Obviously, if, say, for example, the conduct that is being complained of is, I don't know, data theft or breach of confidentiality, something like that, and the investigation is going to be prejudiced by having that employee continuing to be in the business, then as long as you document your thought processes and say, right, okay, well, this is the allegation against them. If this turns out to be true, obviously we wouldn't want that employee in the business whilst the investigation is ongoing. Therefore, we deem it appropriate to suspend, and obviously you would write to the employee to explain why you're suspending them, and explain also that there was no disciplinary sanction implied by your decision as the company to suspend them. Because in that video that we just watched, I think the employer says something to the effect, I've heard some very disturbing news from the IT department, and doesn't give any reassurance to the employee that this is at very early stages at the moment. The matter will be investigated and we will look into that. But in the meantime, we would ask that we will be suspending you with full pay, but also emphasizing to the employee that there is no disciplinary sanction that has been decided in light of what has happened. That will come much later when we get to the outcome after the disciplinary hearing. And again, on the screen there, it says that suspension should be kept as brief as possible. This is correct, but remember what I said before about potentially elongating the investigation procedure in order to make sure that a thorough investigation is being done. Sometimes it will be necessary to suspend an employee for a certain amount of time whilst the investigation is going on. I would say that from an employee relations perspective, getting in touch with that employee just to make them aware that, by the way, we are still investigating this matter, you are still suspended on full pay. We hope to have this situation resolved in the next week, the next 2 weeks, however long it is. The key there, I suppose, is communication with the employee to prevent their anxieties increasing about them being suspended for such a protracted amount of time, if that is necessitated by however long the investigation is going to be. So
I think I'd just add to this as well, that a lot of clients come to us with an idea that they want to suspend as a knee-jerk reaction to a misconduct issue, regardless of what that misconduct issue is. And as Dan says, you've got to ask yourself the question, is it appropriate to suspend? And to be perfectly honest, it will be appropriate to suspend in a very limited set of circumstances, where there is perhaps a threat to other individuals within the workplace. There is a potential that they will interfere with an investigation, and there is a need to remove them from that situation. That you should think about other alternative means of achieving that goal without having to go for suspension. It may be that you can move this individual to elsewhere in the business for a period, or think of any other alternatives to suspension before you end up with suspension. It should be a last resort.
Yeah, thanks,
okay.
Chris.
All right.
So I believe we're going to watch the part 2, the investigation interview now.
Yeah, so this is the investigation. What you'll see in this video is obviously an investigation hearing. Investigations tend not to be a formal part of the process. You tend not to have an individual being invited into an investigation meeting, because at that point, to be perfectly honest, it can allow the employee a period of time to think of an answer to potential questions, and what you want is a contemporaneous account of what has actually happened. So it's quite common to simply pull an employee into an investigation hearing and ask them the questions. Okay.
So hi Eddie, I hope by now you've received the investigation letter inviting you here to the meeting today. Good. As you'll know, there's been a number of allegations made against you by the IT team in that inappropriate images have been found on the company iPad. Do you know anything about this? Have anything to say?
No, other than that, I just can't understand how it kind of happened. It's the strangest thing, and well, I really don't know.
We've got evidence to show that.
I've not downloaded any images. Well, I've not seen any evidence, but I've not downloaded any images. I've never done anything with that iPad other than work.
Well, time will tell on that, won't it? Does anybody at work have any access to your passwords for the iPad?
Well, of course not. I mean, I wouldn't share my passwords for anything at work. It's just not the right thing to do, is it?
Well, you must have accessed them then, mustn't you? But do you understand the acceptable use policy for the IT systems we use here?
I do, of course I do.
So can you explain why there's inappropriate images on your iPad?
I can't. I just don't understand it. I don't understand how this image kind of got there.
Right, well I think that's all for now. So what we'll do is we'll conclude the investigation, we'll write up our report and we'll get it sent out to you in due course.
I'd just like to point out that I was taking a proper note there, just in case anyone wasn't sure. So, in terms of an investigation hearing, it's not common to be accompanied to an investigation hearing, given that it's an informal process. You can allow it. Some employees will request it. My view is, obviously, just take a view. It's important to understand from the employee, well, why are they requesting a companion to an investigation hearing? And is it for support, moral support, or are we concerned that this companion is going to get involved in an investigation and derail it and not actually help to progress the investigation? So like I say, it's to our discretion as to whether or not we allow it. We did allow it here. To be perfectly honest, she was rubbish because she said nothing. But the investigation hearing should not be like that. The questions that were being asked, they were not probing questions. They were not open questions. They weren't neutral. Bear in mind, at this point in time, we haven't concluded that this individual, there is any evidence to show that this individual has potentially done what we're alleging that they've done. At this point, we haven't formed the allegations. At this point, we haven't necessarily spoken with any witnesses to corroborate or to disprove what we may take forward in the investigation. It's very much clear from this that there is an assumption of guilt. The employee wasn't given an opportunity to respond to any of the questions, and it's quite clear from this point that the investigating officer has made their decision on where this is going, and regardless of what the employee may have said to her, she was going to decide that this was heading to disciplinary. So in terms of conducting an investigation, I think the important point to stress on an investigation is the investigation is absolutely key to any disciplinary process. It's the most important bit, and it's the most important bit because that's where all the evidence comes from. You're not doing further investigation at disciplinary stage. You should have done it all by that point. So it needs to be clear, it needs to be thorough, and it needs to be balanced as well. We're not just looking for evidence which supports the allegations and ignoring evidence which refutes those allegations. We're looking for a balanced assessment of all the evidence that's compiled at the investigation stage for the investigating officer then to make a determination of, is this process proceeding to disciplinary or not? Is there a case to answer? It's fairly a good investigation will include an identification of witnesses. So it's important, obviously, that we have to speak to the employee and understand from the employee, well, who was around at the time that the misconduct happened? Who should we speak to determine what happened one way or another? We need to look at documentary evidence. So if the conduct is related to perhaps a data breach or something like that, we need to look at, well, what policies and procedures have we got in place? Are those clear? Have those been communicated to the employee beforehand? Do they understand how our systems work? Do they understand what they can and can't do? It's really important as well that we, as it says there, don't get drawn into making statements about likely sanctions or outcomes. We are very, very early on in the process here. All we are determining on the investigation side is there a case to answer? And if so, at what level should this be pitched at? Is it a misconduct issue? Is the sanction a potential warning or final written warning? Or are we looking at gross misconduct here? Is it serious to be gross misconduct? And also, if you are acting as an investigating officer, look at your disciplinary policy, look at the examples of what amounts to misconduct, what amounts to gross misconduct. They're not exhaustive, but they do give you a decent guide and a decent steer on the potential sanctions you're looking at. Often, clients will get confused at this stage and think, well, it's the disciplining officer who sends out the disciplinary invite and decides what the potential sanction is. The disciplining officer should not see any of this until the investigation report with the disciplinary invite letter shows up on their desk and they've decided that they've been appointed to act as disciplining officer. It's the investigating officer who decides what the misconduct is and how serious that misconduct is, and sets that all out in the disciplinary invite. And I mentioned an investigation report. There is an investigation report, a template example in your workbooks. It's really, really important when we're acting as investigating officers and we're sending out the information to the employees that, firstly, it goes. There's no point just sending a disciplinary invite letter and they don't have the investigation there, because they need to have an ability to challenge what is in that investigation. They need to understand the full case against them and the evidence against them. But also that it's concise and it's easy for the employee to follow. What we don't want to be doing is sending a package of random bits and pieces of documentation and witness statements and various different bits and saying, here you go, sort that out yourself. That is not part of a fair process if the employee is not able to understand the case against them. And it's going to lead to challenge from the employee straight away. It's going to lead to delays in the process because they'll ask for more time to get themselves prepared for the disciplinary hearing. And it's going to immediately set the disciplinary process off on the wrong foot. If we're effectively saying to them, here is an invite letter, but not making it clear what the invite is and what the actual investigation shows. Okay, so as part of an investigation, obviously, if there are relevant witnesses, then we need to sit down and we need to interview those witnesses and understand what their evidence is. And we should also make sure that we keep a record of what those witnesses say, whether we minute those meetings and have the witness sign off on them at the end, or whether they provide a written witness statement. It doesn't need to be all singing, all dancing as a witness statement. We can ask them to put their thoughts in an email. We can ask them to write them down and sign it off. However we do it, so long as it is a clear record of that conversation that we've had with them, it includes all of their evidence, and they're happy to give that evidence as part of this process. So a watch a witness interview, if anyone, while we're watching these videos, if anyone wants to say anything afterwards or give any thoughts or any comments or anything, please feel free to do so, because we're happy to take questions as we go, or listen to people's thoughts as we watch these videos.
And you see this? We've got some stuff here. Just showing here. Picture there, another one there, and over here. And
Oh,
it's just
God.
going to here as well. There's a few more.
It's worse than we thought.
Yeah, I think he's banged to rights here, to be honest.
Well, I think we definitely need to be showing him these, don't we?
Yeah. Don't think he'll be with us much longer.
I agree.
Off you go. Right, well, I'll get all that printed off for you. And then we'll pass it on to you to take it further from there.
Thanks
All
very
right.
much.
No worries.
That's great,
Job
thank you.
done. All right. Easy peasy.
Any thoughts? No? I'll tell you anyway. So, obviously, it took place in a kitchen. That's our Blackburn office kitchen. It's not confidential. You have people milling about in the background. It's not balanced. There's no part of that process which is balanced. Clearly, they're looking for whatever evidence they can get hold of to make sure this is, and I quote, bang to rights, job done. It's not a fair investigation process. And we've got to bear in mind that as we're going through these witness statements and these witness processes, that we still owe a duty to act in good faith towards the employee who is accused of the allegations. And really, as an employee, how do you come back from this if it turns out that actually the misconduct, he hadn't, his conduct wasn't justifiable as a disciplinary process? How do you come back from this when the person doing the interview has sat in the kitchen, other employees are aware, you get half a story, and then you're expecting an employee to walk back into the workplace when clearly these employees know most of what's been going on and what investigation has happened. So it can make the employment relationship untenable if we're not treating this whole process as a confidential process and treating it sensitively, even if there is clear evidence that the employee has done the misconduct complained of. We still owe that to our employee as we go through that process. So in terms of actually handling witnesses, obviously, like I said before, we need to identify who those witnesses are, and that can only come of carrying out a proper investigation and properly discussing it with the employee who is accused, because the employee will know who was present at the time the conduct happened, if anybody, or they will be able to confirm a conversation that they'd had with an individual. They'll be able to confirm dates, times, and specifically what was said, and it's all relevant information. So obviously we confirm the allegations and the situation. We establish what was seen or heard. We get specific information, so we want detail. We don't want a 1 or 2 line witness statement saying, yeah, I had this conversation and it kind of went this way. That's not helpful to a proper investigation. Keep records. So as I said before, an email statement or a written statement or a typed statement or whatever it is fine, but we need a record of that conversation. A common issue that comes up with witnesses is a witness saying, well, yeah, I'll give you the evidence, but I don't want them to know it was me. And it's really difficult to deal with this when it happens, because as an investigating officer, like I said, we owe the duty to the employee who is accused of the misconduct to understand what the evidence is against them and to understand who has given that evidence, because an employee needs to be able to assess the evidence based on who has given it and when, and be able to challenge it. And if we're given anonymous witness statements about incidents that may or may not have occurred, and the employee doesn't know who's given that statement, it takes away part of their ability to challenge the validity of that witness evidence if they don't know who said it, because they may be able to turn around and say, well, Jim wasn't even in the office that day. He was on holiday, so I don't understand how he could possibly have told you that. Obviously, we have to balance that up against, well, why are they asking for anonymity? Is there a potential threat to this individual? Are they worried that there's going to be some physical violence? But we need to explore that and we need to understand it. And I think what we also need to do is make it clear to the individual that they may, and it doesn't happen very often, to be honest, but they may be able to give their witness evidence anonymously as part of this process, if we've done that weighing up exercise. But should this, and we hope that it doesn't, but should this end up in a tribunal, they are not going to be afforded anonymity within a tribunal. They will give evidence, and the individual will know who's given that evidence. As well, often the employee will know who it is, whether they've given the witness evidence anonymously or not, because they're giving an account of what happened on a particular day at a particular time, and the employee obviously knows who was present at that point. So it's not necessarily useful to the witness, and it certainly can be unfair to the employee if we don't go through that weighing up exercise and determining whether or not that witness should be anonymous. I think as well, as an investigating officer, obviously what you have to do is weigh up the evidence that you've got in order to make a determination as to whether or not this progresses to a disciplinary process, and also what the allegations are. And I think my advice to an investigating officer who is faced with anonymous witness evidence is that evidence cannot be as held in as high regard as witness evidence that isn't anonymised, because you need to handle it with kid gloves, really. And what you don't want to be in a situation as an investigating officer is the evidence that tips the balance as to whether or not this proceeds to disciplinary is an anonymous witness statement, because it's a very difficult process then to justify taking that step forward to disciplinary if we're relying on an anonymous statement.
Thanks, Chris. So I'm going to talk to you a bit about, when talking to witnesses, what interview techniques are useful. I always think it's quite helpful to visualize the process of questioning witnesses as a funnel. So it starts out very wide at the top, and it kind of gets more specific and narrower as you go on with your questioning. So to begin with, I would say you should always ask open questions. So things like who, what, where, when, why. You don't want to be asking what I would say are closed questions, so things that can only provide you with a yes or no answer. They're not likely to give you the most information in terms of, because that's your job as the investigator. You're there to extract the information from the witnesses and the employee in question. You're there to get as much information from them as possible, and the only way of doing that is by beginning with open questions. And if you don't do that, it kind of just leads things down a bit of a cul-de-sac that don't really lead anywhere and isn't very useful in my experience. So who, what, where, when, why questions. It's also important to remember that if a witness is particularly reluctant to say more, to say maybe they're not, they're people of few words, you can still ask open-ended questions, but just probe a bit further. And sort of ask them why a particular thing happened, why aren't they saying as much, what's going on, things like that. Obviously confirm the allegations and the situation. Now with particular witnesses, the reality is they will have first-hand knowledge of what the investigation is about. They may not do, but for reasons of confidentiality, we should obviously always be making them aware of broadly what's happened, but not really confirm identities and things like that when questioning them. So if they ask us questions as the investigator, oh, well, what's this all about? I can't really say that much at the moment. I've just been asked to investigate a particular incident on a particular date. So please, can we carry on with the questions? There's nothing wrong with being fair with witnesses or the employee who's currently under investigation. Again, establishing what they saw and what they heard, and then even confirming that back to them. In times when I've been asked to carry out either investigations or disciplinaries or what have you, I always make sure that when I've made a note of what we've discussed, I'll always probably send a copy to the relevant witness or person I've interviewed and ask them to just make sure that they confirm that I've got everything down correctly. Certainly in the wake of the pandemic, we've seen a lot more employers and clients who have had to carry out investigations and disciplinaries in the forum that we're speaking in now, which is obviously not ideal when you conduct an investigation. The preference should always be, if it's safe, to have it as a face-to-face interview, I would say. But for purposes of time, people's availability, location, things like that, I suppose one good thing to come out of the pandemic is that an investigation, there's no barrier to that because we can obviously use virtual meeting software to conduct interviews with people who say are a particular distance or length away from us, and that shouldn't be any barrier to an investigation pushing forward. Like Chris said before, obtain the specific information that you want. So if you do want somebody to confirm something, there's nothing wrong with asking the direct question. So this would be a closed question. Did you see so-and-so download this particular image onto his computer on this date? There's nothing wrong with starting with open questions and then maybe towards the end of the interview, rounding it up with a number of closed questions. Keep records. Again, I've already touched on that point. Keep accurate records. So obviously you would make your own notes as you went along. If you benefit from a note taker with you, obviously they will circulate the minutes of the meeting or the interview to the people involved and ask for their clarification, just to double check that they are an accurate record of what was discussed. And again, Chris has already touched upon witness anonymity, so I'm not going to discuss it in any more detail. Safe to say that really, if it's a particularly serious allegation that could result in a dismissal and maybe that dismissal being challenged, if a witness says to you, well, I'm not really comfortable in having my name attached to this statement, you as the investigator kind of have to think, well, can I use that? What's the reason for this witness's reluctance to have that included or to have their name tied to this statement? If there is a genuine fear of pardon me, what I would say are reprisals, so maybe some physical violence to themselves or to someone they care about, things like that. In those instances, I would say maybe anonymity can be considered. But even then, I would say that, as Chris said before, probing the reasons why the witness wants to be anonymous is always important, and documenting the reasons that they give, and then you as the investigating officer making a deliberation as to whether or not you are going to use the statement if they've given you permission to use it. If they say, look, if I have to provide my name to this, I don't want to be involved, then absolutely you can take that on board. And as long as there's sort of a document of your thought process as the investigator, you shouldn't go too far wrong.
Daniel, can I just ask a quick question on this?
I'm going to ask you to identify yourself because I've got a voice. Oh, hang on. Is it Emily?
It's Emily. Yeah. Hi.
Yeah. Hi.
Just a quick question. We've had instances in the past where witnesses have wanted to keep that anonymity because they're in the same team as the employee who's going through this process, and therefore they're sort of concerned about, depending on the sanction, if they're expected to then continue working with that employee, how that harms that relationship. We've sort of taken the approach, sort of, as you've touched on, that, generally we don't, we wouldn't rely on that evidence then if that person wanted the anonymity and say, look, we're not prepared to put anything into the file. If you're not prepared for it to sort of have your name attached or to sort of associate yourself with it. Do you think that's sort of the right approach, or?
I think, as Chris said, it kind of needs to examine, the reality is, I mean, if this person's in the same team as that person and that person's being investigated, and say an allegation has been put forward to that particular, to, you know, the employee in question who's under the microscope, if you like, if they're in the same team, is it likely that that team is going to sort of talk outside of work, and that knowledge will get to them anyway? Or so and so is in the office giving a statement to such a person. It's a question of sort of examining it on that basis. But I think it would, just from I see why you would want to, because you want to preserve employee relations within the team. However, if it's a sufficiently serious allegation, you know, you've got to be honest with the witness and say, well, this is a particularly serious allegation that we've had against employee X, whoever that is. And, you know, we do want to move ahead with that. If you're not prepared to provide or, you know, to give any statement to us in respect of this situation, then, you know, fine, we will proceed down other avenues if we need to. I suppose it depends on the seriousness of the allegation. The more serious it is, and the more likely it's going to result in a very, you know, maybe a final written warning or a dismissal, you know, you would probably want to have the ability to use that information if at all possible. Yeah. And I don't know if, Chris, if you've got any other thoughts on that.
Yeah, I mean, and it's quite a common issue. So you're not alone in that. I think Dan's right. If we're looking at a gross misconduct issue, we need our employees to buy into our process and understand that this is a really serious issue, and we need their evidence as part of that process because we're reliant on them. But also, as our employees, there should be an expectation that they will assist with an investigation if there's a requirement for them to do so, as part of their role as our employee. Appreciate there are personal relationships and things like that, but if the tables were turned, we would expect the other employees to do the same. And I think, excuse me, I think the issue is that when you get employees, I suppose, closing ranks and nobody will talk to you about anything. But I suppose it's a person management process to go through to make it clear to them that, look, there is an expectation here. If you've seen something, you need to tell us what that thing is that you've seen, because we need to ensure that this process is fair, and we need to ensure that it's being dealt with appropriately as part of this ongoing investigation. So I think you can be fairly firm with employees who refuse to provide that information. Obviously, if you don't need it, if you've got CCTV of an incident or something like that, you may not push us as hard. But if we are relying on somebody saying something or somebody witnessing something, and all that saw it was a group of a few people in their team, we really need to be clear with them that, look, please provide this evidence. We expect you to do so as part of your obligations to us as our employee.
That's great, thank you.
No problem.
Okay, so thanks, Emily. So just to turn to sort of the end point of the investigation, what other evidence and information do you need to consider? So obviously we've got witness evidence, we've got probably a statement from the employee in question or the employees in question. What other evidence would you as the employer need to look at in order to sort of to complete and round off your report? Documentation and records, obviously. When I'm going through these, I always ask people to kind of think of how easily they're going to be able to get access to this particular information. So say, for example, CCTV, really good example. How quickly are you as the investigator, if there is CCTV evidence, are going to be able to access that and then maybe present that in a format that the employee is going to be able to look at, to watch. I've had it a few times where the employer has gathered the evidence and then sent it to the employee with the letter, the invite letter. But the employee, for whatever reason, has not been able to access and to look at the other information, such as CCTV footage, which has been a problem. So it's thinking of things like that as the investigator. What type of information are you going to need to present in your report that's then going to be sent to the employee as part of the disciplinary process? Obviously, if it's things that are on computers, you'll need to liaise with your internal IT departments, or if you deal with that, You'll obviously have to be familiar with the processes of extracting that information from your computer servers and what have you. Do you need to look at any training records? Where are those training records? These are types of things that we've certainly in the past few months, due to the pandemic, have been a bit of an issue because a lot of people are working from home. Access to the office is limited, and say, for example, a person's personnel file is sat there in a drawer in the office somewhere. It's not online. They can't access it, and they're not permitted to enter the building. I think certainly now, as certain lockdowns begin to ease, that's become less of an issue. But I suppose that the key thing to remember as the investigator is, right, okay, as well as my witness information, my witness evidence from the people I've interviewed and the employee, what other evidence am I going to need to sit and go through? How long is that going to take me? How long is it going to take for me to get access to that? And how am I going to present that in a report to the employee in a manner in which they understand and can watch? So just to talk a little bit about the report itself, and what kind of burdens of proof you are working to as the investigating officer. It's not beyond reasonable doubt. It's not criminal liability we're looking to establish. That's a really high threshold. What you're looking to do is to establish on the balance of probability whether or not something happened. So that if you think about it that way, that the threshold, the burden of proof is a lot lower. You don't have to sort of go to the ends of the earth to prove someone's guilt or not of a particular allegation. All you need to establish is the balance of probability that this probably happened, and all the evidence seems to point to this person doing this thing on this day in this way. So is there sufficient evidence to suggest it's more likely that allegations are true than false? Again, that's the only thing you need to consider. In compiling your report, I would say that the sample report that's provided in your workbooks, you won't need to use that for every instance of misconduct or conduct. I think for examples of gross misconduct, you would, because with gross misconduct being quite a serious allegation, if it's proved, it's likely to result in the person being dismissed. You want to have a document that is fairly comprehensive in terms of who you've spoken to, what questions you've asked them, what other evidence you've considered, and on the balance of probabilities, what you think the allegation is that there is against this person, and whether or not that necessitates formal action in the way of a full-on disciplinary hearing. If that is the case and you've compiled your report and it is sufficiently serious that you need to sort of put it together and send it to the employee with the invite letter, as Chris mentioned before, as the investigating officer, once you've amassed all of the evidence and you're compiling your report, it's important to keep out, as you will have done when you've been interviewing people, keep out any value judgments or subjective opinions that you may have about the particular situation. It's often the case when I speak to certainly to people who own their own business and are conducting all of this themselves, maybe in smaller enterprises, they get caught up in the sort of I would say the fact that it's their company and that they take it personally, this person has done this thing, and they start putting all sorts of things in the investigation report that is completely, what I would say is biased, subjective, and of no use to them really, because it just looks as if the decision has been predetermined. So when compiling the report itself, it's important to keep out any of that judgmental language. All you're there as the investigator to do is to present the evidence that you've gathered and say whether or not you think it's more likely than not that this means that disciplinary action is merited, and make a recommendation as to what that should be. So here we've just got a brief overview of how you would usually set out your investigation report. So obviously the beginning, you would just set out the introduction. What's the purpose of this report? What's it being asked to investigate? Certainly for instances of misconduct involving say maybe one or more employees, you want to have one that deals with one employee, so keep things separate. Although it does so happen that sometimes you know, when you're compiling a report, you make sure that you have all of your witnesses listed, who you spoke to, when you've spoken to them, minutes of the conversations you've had with them, an explanation of who you spoke to and when, what you did. And then you conclude all of that by saying, well, look, this is the things that I've considered. These are the supporting documents, which may not have formed, say, a great deal of your decision making, but certainly help from a disciplinary point of view and supplement the evidence that you've already gathered. And again, there are some tips that I've already ran through. Use objective style and appropriate language. Stick to the facts. Don't put any judgments or anything what you think may have happened. It's not the place to start telling people your opinion. Be formal, be clear. Avoid any nicknames or colloquial language unless nicknames and colloquial language have been used in, say, a witness interview, and maybe you would just put an explanation of so-and-so is often referred to as this in the workplace. You could cover it off that way by stating that this is how this person refers to this other person. So it doesn't need to be War and Peace, but again, it does need to be thorough enough. And certainly we keep talking about this, but the more serious the allegation, the more, I suppose, the lengthier your investigation report, if you compile one, which I recommend you would, is going to be. So if you think about it that way, less serious instances of misconduct, which could probably usually be dealt with informally anyway and not really necessitate a full disciplinary process. But if there is, you would still go through a sort of a process compiling some sort of report. It doesn't need to be a full-blown report, but certainly for the more serious instances of allegations of gross misconduct, where a dismissal or a final written warning is likely, you're going to want to compile a complete report that covers all of the things that we've spoke about. So I'm going to pass you back to Chris now, who's going to talk to you a bit about the disciplinary hearing itself.
Right, so we're at the main event, which, in terms of the disciplinary hearing, obviously, and I suppose you can tell by the amount of time that we've actually spent on the investigation, how important the investigation is. The investigation sets up everything else involved in this process. And sets up where we get to in the disciplinary hearing. So in terms of an actual hearing, the formalities of the hearing, we need to make sure that we have a formal invitation letter sent to the individual. We provide the investigation report, we provide the evidence. What can happen sometimes is when you're looking at things like video evidence or CCTV or something like that, obviously a lot of the time it will be either impossible to send that to an individual, or it would be a breach of confidentiality to do so. And what I tend to advise employees to do in those circumstances is set up a new investigation meeting ahead of the disciplinary hearing, so that they're able to see that evidence, they're able to comment on it, they're able to take notes, and they're able to understand exactly what that shows, so that they can deal with it when it comes to disciplinary hearing. Under the ACAS code, which we'll get onto later, we need to give at least 48 hours notice. They need a reasonable opportunity to be able to run through the evidence, particularly if the investigation report is long, and particularly if they're facing serious misconduct, gross misconduct issues. They need an opportunity to be able to go through all of that, understand the case against them, prepare, and also, importantly, the next step, which is the right to be accompanied. They need to be able to arrange accompaniment. I suppose in the current circumstances, accompaniment can be either very easy because someone can jump on a video call with you, or it can be quite difficult, particularly if there is a trade union involved, or there's an unavailability of a particularly work colleague that they want to be accompanying them to the hearing if they're still on furlough, for example, or something like that. There is actually an ability for individuals who are on furlough to take part in as companions within any processes going forward. It doesn't breach the furlough scheme to do so, but there are additional, I suppose, technical issues and practical issues at the moment, given where we are. What we also need to consider always with any meeting that we're involved with is, does this individual require reasonable adjustments? Are we aware of a disability? Is there particular adjustments that we need to put in place, such as access to, if we're having the meeting face to face, access to the meeting room that we're proposing to use? Do we need an interpreter if the individual doesn't speak particularly good English? It doesn't come up very often, but it does happen. Taking minutes of the meeting, really, really important that whoever is acting as disciplining officer has a note taker with them. Or if we are doing the meeting virtually like this, we agree that we record the meeting as a full record of the meeting hearing, and it's really important that we agree it. We don't just want to press record on the button on Zoom and record the meeting without taking permission. So have that conversation at the start of the process, and get agreement to recording the meeting, and also providing, either if we are taking minutes, providing a copy of those minutes for the individual to comment on, or providing a copy of the recording. And then in terms of adjournment, never make a decision on the day. Never sit in the disciplinary hearing, go through all the evidence, go through all the allegations, listen to the employee in terms of their mitigation evidence, and then make a decision while they're sat there in front of you. Because even if you have only come to that decision after hearing all the evidence, it just looks like you've walked into that hearing with a preconceived idea of what outcome you're going to give, and it doesn't matter what the employee is going to say to you, you're going to give that outcome. So we'll move on to the disciplinary hearing. Again, if anyone's got any comments after this, just let me know, and we can talk through them afterwards.
So, welcome Eddie to the disciplinary hearing today. I note that you're accompanied by your witness Olivia, and I'm also accompanied by Mark, who will be taking the minutes for us today. Just wanted to make you aware of what your obligations are in this meeting, Olivia. You're here to support, you're not here to contribute, and if you do start overstepping the mark, then I will have to adjourn the meeting. I assume, Eddie, that you've seen all of the evidence that we have against you at present, and you received this prior to the meeting?
Yeah, I've seen the stuff you sent.
Okay, so you'll note from the letter that we provided to you inviting you today that there are two allegations against you. The first, that you've been accessing indecent images on the company iPad, and the second is that your actions have constituted a fundamental breach of the IT procedure. Have you got anything to say for yourself?
No, other than that, I just really do not understand how these images have got there. There's no reason why they would have appeared there because of anything I've done. It's just, I mean, I've seen the images that you've sent me, and I understand that they've obviously been found on the iPad, but I just can't understand how, because I've never downloaded anything onto the iPad other than things that I would have required at work. But
you're saying to us that you've never let anybody else access the iPad, or that you've not released your passwords to anyone, so how can it not be you?
Well, no, I mean, there's no one else at work that would have the access to use it other than me.
Well, I think that speaks for itself, really, don't you? Anything else that you'd like to say?
I've nothing else I can add.
Right, well, I think really we're at a point where a decision needs to be made, and having assessed the evidence and what you've got to say for yourself, I feel there's no other way that we can deal with this other than to dismiss you for gross misconduct. So here's a letter confirming your dismissal, and I'd like you to leave with immediate effect, and you'll be escorted from the building immediately.
My favourite part of that video is that Stuart is now wearing my tie to make it look like a different day. So has anyone got any thoughts? There are some positives to take out of that. There's not many, but there are some. But has anybody identified any particular issues? Anybody wants to sort of share the thoughts? I know the answers, so it's a bit boring if I do it. No, that's fine. So obviously, as I said before, the letter was clearly already there, ready to go, regardless of what was said in the hearing. That was the decision she was going to make. As well, the investigating officer was the same person who did the disciplinary hearing. It's really important that we have individuals who have no involvement at each stage of the process. We have a separate investigating officer, a separate disciplinary officer, a separate appeals officer when we come on to the appeal to make the decisions. Because unless you are a very, very, very small company, there should be no reason why you can't have 3 individual managers doing each individual stage of the process. And it's really important in terms of fairness that we do that, because all we have here is a disciplining officer backing up the decisions that she made off her own investigation, and it can make a process unfair if we have the same individual doing both of those processes. Some positives, obviously, right to be accompanied. So we got that right. There is a right to be accompanied under the ACAS code to a disciplinary, and he was accompanied. She did ask, although I suppose her manner was quite aggressive, she was asking probing questions. You are entitled to, in a disciplinary hearing, once you have the investigation confirmed, and you have the allegations to take forwards, you are entitled to put the allegations to the individual and ask for their comments, their answers to their questions, and to challenge them more. It's not an open conversation at that point. It's not a gathering of information. We've done all of that. We've done our investigation. We've now got to put the evidence that we have gathered as part of the investigation to the individual and challenge them on what they say in response. So in terms of the decision, obviously, we need to consider, we need to be clear on sort of our thought process in a disciplinary outcome letter. What we don't want to be doing with a disciplinary outcome is a very quick half a page, I find that these allegations are proven type outcome, because one, it doesn't show how we've weighed up the evidence and come to the decision that we've made, and two, you're going to get an appeal if you do an outcome letter like that, because the employee is going to simply disagree with the outcome, but in terms of a fair process, they're not given an opportunity to challenge the considerations that the disciplinary officer is taking into account when making that decision. So a disciplinary outcome, particularly in circumstances where we're talking about a dismissal, as here for gross misconduct, needs to be very clear, very well reasoned. It needs to address each of the allegations, outline the evidence that was gathered as part of the investigation, outline any aggravating factors. We need to take into account any mitigating factors that the employee has put together in order to determine what sanction is appropriate. And we need to consider whether if the allegations are proven, what the likely penalty is once we've done that exercise. We need to consider what we've done in the past. So a lot of the time, employers will have looked to have given a final written warning for a similar act of misconduct, which they then want to dismiss for gross misconduct. And it's very difficult if you look to do that with a separate employee, because the employee can very easily turn around and say, well, I know that you gave Dave a final written warning for doing exactly the same thing. It's very important that we consider what we've done previously before we impose a sanction. So what we'd also look at in terms of mitigation, and also in terms of aggravating factors, a disciplinary record. So have they got existing warnings? Are we building on a previous warning which is still live? Their general work record, their position and seniority. So obviously we expect a higher level of good conduct from our managers, from our supervisors, from the individuals who've been with us for a period of time, and who are our stalwarts than we would for an individual who's not been with us that long. And it is fair to consider it in that way, because there is a higher expectation. Is the proposed sanction reasonable? So the band of reasonable responses it comes from case law. It basically says, is the decision that we are going to impose off the back of this disciplinary process, is it justifiable? Is it reasonable that this deserves a dismissal for gross misconduct? And what you always should do is keep referring back to your disciplinary policy if you're looking at bands of reasonable responses. If something is listed as an issue of misconduct, you do not want to be dismissing for gross misconduct. It's as simple as that. The employer should be informed in writing. That decision should be clear. It should be well reasoned. It should give as little room for challenge as possible when we're coming to make the decision. And if we are looking at dismissal, you always have the two options available to you. Is this serious enough that it warrants dismissal, but isn't serious enough that it warrants summary dismissal, so dismissal with no notice? Or are we talking here about the top level of misconduct in terms of seriousness, which justifies a summary dismissal for gross misconduct? And the right of appeal, again, it's in the ACAS code. We need to give a right of appeal. Individuals need to be given the opportunity to appeal against the decision that's been made on the basis of how that decision's been made, whether that be that they have further evidence to put forward to change the decision, or they identify a gap in the investigation which could be supportive of their position, or whether even they decide that the actual procedure that we've been through is not a fair process and they're challenging it on the basis of procedural unfairness. It's important that we're clear in our letter what the time frame for appeal is. So generally it's 7 days after the decision. We can extend it depending on individual circumstances. Sometimes it is justifiable to extend it depending on what the employee says to us, and it always makes us look good as employers if we give them extra opportunity to appeal. The appeal needs to be held by an appeal officer who is impartial, so they should have no knowledge of what's happened previously. They should come to this afresh, and they should be, if possible, more senior than the disciplining officer, because what we don't want is a disciplining officer who is the MD or a very, very senior manager, and then passing an appeal to an individual who is lower down the rungs of the organisation, because at that point we're always open to challenge that this is purely a rubber stamping exercise, and we've rubber stamped the decision of the disciplining officer because they are more senior.
Okay, thanks, Chris. So this is, I think it's the second to last video that we have today. So this is an officer taking the employee through the appeals hearing. The appeal can often be a way to correct, as Chris has already stated, things that may have gone wrong procedurally, or to obviously to provide the employee with an opportunity to provide new evidence that may make the appeals officer either overturn or uphold the decision of the original decision maker. So as with the previous videos, I'll just play this one and then see if everyone's got any thoughts on what the employer did correctly in this particular circumstance. Oh, sorry about that. I can't seem to play the video. Kane, can you assist? Oh, hang on, there we go. It's come up. I've got the play button. Sorry, everybody. Right, here we go. Take two.
Thank you very much for coming along today, Eddie. As you know, I'm the appeals officer. I've got Mark with me on behalf of the company today, so he'll be taking a note of everything that's said, and the minutes can follow following today's meeting.
I don't know what's happened there, everybody. Let's just try and go back.
Thank you very much for coming along today, Eddie. As you know, I'm the Appeals Officer. I've got Mark with me on behalf of the company today, so he'll be taking a note of everything that's said, and the minutes can follow following today's meeting. I understand that you've got Olivia here with you as your companion, and that she'll be here in a supportive role for you today. Obviously today's hearing is all about your appeal. I have seen your grounds of appeal within your letter, but today is about giving you an opportunity to say everything that you want to say on your grounds of appeal, and so that I can make a decision really and review that earlier decision that's been taken by the company to dismiss you without notice on grounds of gross misconduct. There are some possible outcomes following today's hearing. That could be either that I agree with the earlier decision and that your dismissal without notice stands. There will be no further right of appeal beyond that. I could alternatively award a lesser sanction, such as a first written warning or a final written warning, or potentially even consider other options within the business. And finally, I could overturn that dismissal, and so there will be no sanction. So they are the options available to me. In advance of today's hearing, I've reviewed your appeal letter, of course, the investigation report and the witness statements that I've got here. I've also looked at the minutes from the disciplinary hearing and the outcome letter, so the dismissal letter, and I've read all of them in advance. Based on your letter and grounds of appeal, I understand you've got 3 grounds of appeal that you want to go through today. The first is that you've got new evidence. The second is that, as a business, the investigation and disciplinary failed to consider if there was any access to the iPad from home, and thirdly, in relation to procedural failures. So what I want really to do now, Eddie, is just put it over to you to outline your grounds of appeal so that I can make a decision really beyond today. So you must feel that you've been given every opportunity to say what you want to say. And just let me know, each of those grounds what you've got to say.
Well, I think the key point that I went away and thought about was how could this material have got onto this iPad, and I just think the investigation didn't really cover enough of what actually the circumstances might have been where that was downloaded. Yeah. Obviously, I've said all along, I think, I've been quite clear, no one at work has ever had access to my iPad other than me. Yeah. And I think that really speaks for itself in that I wouldn't share my login details at work, but I suppose what I did think about was at home sometimes my family do use my iPad from time to time to browse the internet, and essentially I think that there's a chance that my son could have downloaded something one weekend whilst I was actually away on business, and Peter, my colleague, he was with me. He's actually prepared to provide a statement confirming that I was out of the country that weekend, and neither did I have the iPad with me. I didn't need it. So I think that's the first point that I raised that wasn't covered in the original investigation. And then the second area where I think you talked about procedural issues. I just think it was most unfair that really the same manager acted to investigate this matter and then made a decision. I think from doing a bit of reading on the internet and understanding the ACAS guidance and the code of practice, I think it's most improper that really one individual has just acted to make this decision without necessarily following the procedure. But I'd like that to be considered as well.
Okay, so that's quite a bit of new evidence that you've established. You've said that you're going to be able to get a statement from Peter. You've not got one at the moment, have you?
No, I mean, I haven't got one, but obviously as part of the investigation he's willing to provide that.
I can go away following today and have a good discussion with Peter and take a witness statement, and I'll certainly get all of that. Rest assured that I will be looking into this following today, and all of the points that you've raised. Obviously we've got a good note of that, and it may be that following my investigations I need further discussions with you. Do you have any travel documents or anything that proves that you were away at that point in addition to Peter?
Yeah, absolutely. I mean, they were sent to me on my work email account, so I mean, I don't have access to those, but I can obviously tell you the dates that those would have been received roughly, and
well, that would be helpful.
I presume you can retrieve them via the system.
Okay, well I will go away and look at some evidence on your email account relating to that. I'll also talk to Peter and get clarification about you being away on business. It sounds from what you're saying that was of the same dates of this, and I'll make sure that is the case. And if there is anything further I need to consider following this, or I need further questions asking, I will contact you. Otherwise, as I said, I will go over all of the evidence again in detail. I'll conduct this further investigation, and only then, when I've got all of the facts and the details in front of me, will I be making a decision. No decision has been made at this point in time, I must assure you of that. Once I've got all of the evidence together, I will invite you back, and I'll talk to you about the decision that I've ultimately come to, and I will try and deal with this as a matter of urgency, because I appreciate in the meantime it's very difficult for you to be dealing with this if ultimately what you're saying is correct. So thank you very much for coming along today.
So several things there that were present, that weren't present in the previous disciplinary procedure. You know, there was a lot of, we will look into this, no decision has been made as yet, we will take on board the extra evidence that you provided, and will conduct a thorough sort of examination of that evidence in order to determine whether or not we're going to change our decision, which is correct and proper. I think that the appeals officer does a very good job of explaining to the employee what's going to happen, what her options are in terms of decision making, and being very clear with the employee as to what will happen next and who she will speak to, and you know, the fact that she will bring him back in to explain her decision if it's different, or if it's not to what the original decision was. So I think that's a really good example of how an appeal can, I suppose, it's not ideal, but it's good, because the appeal has undone some of the damage that has been done earlier on in the process at the investigation and disciplinary stage. I wouldn't advise anybody to rely on that and think, oh, well, it doesn't matter, I'll do whatever I like for the investigation and disciplinary because I can just deal with whatever issues have cropped up at the appeal stage. No, that's not the way we're advising you to go about these, but it's reassuring to know that, say, for example, if a decision has been taken out of your hands and it comes to you and you think, oh God, this is a mess, well, they've still got the right to an appeal, so I suppose we can start now and begin correcting some of the issues that have already arisen in the earlier stages of the process. Don't know why it's done that. So an appeal, just to sort of do a brief overview because I'm conscious of the time, an appeal can be either a review of the evidence that is provided by the employee. Say, for example, if they've got new evidence that they didn't have before, it's always important to take that on board and consider that and think, well, as the company, is this going to make us change our mind? Is this going to make us reverse or uphold the decision that we've arrived at previously? Or it can be dealt with as an entire rehearing of the initial allegation. It's rare that that happens, but it can happen occasionally. But usually, more often than not, certainly the ones that I've dealt with, it's tended to have been an instance where the employee has provided some new material, some new evidence for the company to consider that maybe potentially changes the mind of the company in respect of their original decision. So what new evidence is provided? It could be anything. It could be a witness statement, as in the video example there. It could be a witness statement from somebody who corroborates that employee's whereabouts. Well, obviously, if he was on business, he couldn't have accessed the iPad because it would have been at home, and he's got a colleague to vouch for that. It obviously goes really well in his favour, potentially. So it's important to consider the new evidence, and if there is any further investigation that is necessary, and you heard the appeals officer mention this, if there is any further information that the appeals officer needs to go off and collect, they should have the authority to, of course, to go and do that. And obviously they will deal with it as soon as they can. But again, as I said before, in respect of the initial investigation stage, it may be that such a person who they need to speak to is away on annual leave. They can't come back for an interview until such a date in the future, in which case it's going to put the brakes on that appeals process potentially. In order to demonstrate fairness, I would probably have advised in that situation where somebody is away, wait till they're back, have them sort of talk to you about that particular issue and gather their evidence that way. So this is a video. You tend not to have appeal outcome hearings, usually you can deal with the outcome of an appeal by way of a letter, and any sort of evidence that you've considered along with that letter, similar to the initial disciplinary, but sometimes it will be in particular companies' policies and procedures that the employee is provided with the right to a hearing where the outcome is delivered. It won't always be necessary in every case, but we've done one here anyway to help illustrate the point of what evidence has been considered and delivering that information, the outcome of the appeal to the employee. So I'll just play the video and then we'll crack on. So hopefully this works first time round.
Thank you very much for coming along, Eddie, today. As promised, I've now conducted the investigation that I said I would. I've interviewed Peter. I've got a statement from Peter which I've sent to you in advance, and I've also had a statement that you've sent that you got from your son. I've retrieved the travel documents from your account, from your emails, and that does show that the dates and the times of your travel coincide with all of the dates of the individual images that were downloaded, and therefore that clearly you were out of the country at that time. The statement from your son is clear that he did download those images and that he had access to the iPad whilst you were away on business. So on that basis, I am satisfied that you have not downloaded those images, and I want to overturn your the decision to dismiss you for gross misconduct and without notice. I do, however, have to say that I am concerned that you've allowed access to your iPad and to your son whilst you've been away on business, and that clearly amounts to a breach of the IT policy that you've had in advance of the disciplinary hearing. So on that basis, whilst the decision has been overturned in relation to your dismissal, I do feel that that breach amounts to a final written warning, and that's the sanction that I'm going to give going forward. That will remain on your record for 6 months. You do have no further right of appeal now in relation to this. So I do understand that this has all been extremely stressful for you in terms of the disciplinary hearing and the outcome from that disciplinary hearing, but I hope now you've had this decision that you can draw a line in the sand and move on with your position.
Well, thank you very much for listening to what I had to say, and obviously for doing a lot of re-investigation. I understand that I shouldn't have shared the access to the iPad, but I am really grateful that you've actually found out the facts and what happened here, because I just, as I say all along, I couldn't understand how it could have been the case that imagery had got there. But thank you very much.
You're very welcome. As I said before, let's hope we can move on, but I will convey my decision in writing to you to explain how I've reached the decision, and then you've got that, and that will obviously look on will go on your personnel file. Thank you.
Wow, so it gets my Oscar nomination. I don't know about anybody else, but a cracking piece of theatre. So just to recap on what's happened in that meeting, again, it's not common to have appeal hearings where you deliver the outcome in the manner that they've done. Usually the things that the appeals officer was saying, you would simply set those out in the letter. So number one, the original decision has been overturned because on consideration of the evidence provided by the employee, it kind of exonerated him, didn't it, from the fact that he wasn't anywhere near his iPad when these images were downloaded. However, the employer was quite clear, the appeals officer was quite clear that although the decision in terms of the dismissal has been overturned, because of the fact that it's a company iPad and he's obviously divulged his password or left it unpassword protected for members of his family to use, that does amount to a breach of the IT policy. So what the appeals officer has done is obviously just downgraded the decision. So it's no longer a dismissal, but it is still a conduct point. It is still a breach of a policy, and it is quite serious because it's led to a full-blown disciplinary of this person and could have led to other sort of issues of data security that the company obviously wants to address. So they've downgraded that decision to a final written warning, which I think is probably fair in all the circumstances. And the employee would probably be quite relieved in respect of that because they've still managed to keep their job, albeit with a final written warning on their file that will remain. And the appeals officer was quite clear with that, how long that would remain on his personnel file for. So obviously, if there was any other instances of this, he would probably be looking at a gross misconduct or at least a conduct dismissal if such a situation happened again, because he's already been given one final written warning for it. We're going to go to the next slide now, which is discussion points, but I am conscious of time. So I'm probably, Chris, if you agree with me, do you think we should get to the end of the presentation and then see if people want to ask questions, or are you comfortable with that?
Yeah, absolutely. I think these are points that you just have to bear in mind when you're going through a process, because obviously the answer to these questions is potentially the process would be different if they had less than 2 years service. Apply to follow a full disciplinary process when we're dealing with an individual who has less than 2 years service, because they don't have the right to bring an ordinary unfair dismissal claim. However, we still need to be aware of the fact that there may be discrimination elements involved that may be thrown up as part of the process, and we need to be alive to those and deal with them. Whistleblowing as well, particularly at the moment, breaches of health and safety obligations and things like that can be automatic unfair dismissal as well, and we need to be conscious of that, because that doesn't require the 2 year qualification period, so that they are just listed there. But there are things that you just need to be thinking of initially, and obviously if you're unsure, take advice.
Yeah, that's key. I think, I suppose, whenever someone does come to me with a dismissal, or a potential dismissal, I should say, in respect of someone who does have less than 2 years service, there's no harm in following a semblance of a process where you can invite them in, take them through the main points of your concerns, of whatever they are, and then see, what their reaction to that is. If they don't offer anything in mitigation in respect of, oh, I did this because of X, maybe the person is suffering from a disability or something like that, then at least you've covered yourself as the employer to look at that and say, well, they didn't raise any of this when I brought them in, gave them the opportunity to present any sort of mitigating evidence as to why this conduct's arisen, and you've kind of at least you've addressed your mind to it and provided the opportunity to the employee to speak on that. If nothing's forthcoming, then obviously you can then make the dismissal in confidence, if that's what your decision is. Okay, and I think I'm gonna hand back to you, Chris, to speak about procedure in ACAS. I don't know if that's...
Yeah, so in terms of procedure, procedure when we're talking about a disciplinary process is key, because you can have a fair reason for a dismissal based on the conduct of the individual, but if you don't follow a fair process, the dismissal can be procedurally unfair in any event. It's important that when we're going through a process, we are obviously following these key principles. And these are the principles which are outlined in the ACAS Code of Disciplinary and Grievance, and we need to take those into account, because as at the bottom of the slide there, if we don't take them into account, even though the ACAS Code is not legally binding, if we did end up in tribunal and the decision was that the dismissal was unfair, there can be an uplift of up to 25%. Of the compensation awarded due to a failure to follow the ACAS code. I think the point around this is, if you have a properly drafted disciplinary process and you follow it, you will be complying with the ACAS code in doing that. So just to recap, in dealing with dismissals, we need to show there's a fair reason for dismissal. We need to show we've acted reasonably in all the circumstances. This is where the fairness, the balance, that approach comes in. In terms of reasonableness, obviously, what is reasonable for a massive multinational company is not necessarily reasonable for a small 10-person company, and that is taken into account. But you should, as at the very, very least, be following the ACAS code when you're going through your processes. Again, the band of reasonable response is the sanction that we're looking to impose available to us as a reasonable response? Have we been consistent in how we've treated the individual? Have we followed the same potential sanction of previous issues of misconduct or Are we treating them unfairly or unfavourably in doing a more serious sanction? And like I say, procedural fairness. We need to follow a fair process. It's not just about the fair reason, it's about following a fair process as well. Okay, so sorry that there was a few technical glitches, but I think it went as well as we could have expected. But if anyone has any questions, then I appreciate we're sort of 15 minutes over, but we're happy to answer questions if anyone's got any.
A deadly hush descends.
I think that just proves that we've answered all your questions in the presentation. If anyone's got any questions, obviously appreciate it's difficult doing this virtually, and some people don't necessarily want to speak up. But me and Dan, we're around afterwards. You can ring us, you can email us. It's really not a problem. Just let us get in touch if you've got anything that comes off the back of this, or you want specific help with something that you don't feel like you can mention here. We're more than happy to help, obviously. Right. Should I hand over back to you, Kane?
Yeah, that's great. Thanks everybody for joining us. So like I said, the recording of this will follow shortly. And also, if anybody didn't get the workbook, just let me know and I can send you a copy of that as well. Thanks very much, everybody.
Thank you.
Thanks.
Cheers, guys.